Your Honor, as we search, we do have the application miscellaneous number
Who should address
76.
the court? Who has moved to the court?
Yes, if you can have a copy of the affidavit. I think all the copies were given to the court kindly.
No, we don't have time. If you are not ready, then we can have this matter heard in the morning. The prosecution, you're saying you don't have your application, you don't have your copy.
We now have a copy. They are all received at the registry.
If that was the case, we could agree by consent to come tomorrow. So,
So
But-
now she doesn't have
Very
her
good, very
copy. And
I have a copy. We are
No, she
ready.
has
The
a copy.
investigating officer is in court. We are ready to proceed with the application.
you're ready with the two applications.
Yes.
You have a copy for the other.
The miscellaneous application is 769 of 2026.
There is also E770. Do you have a copy?
I do not have a copy of this one.
See, that shows you are not ready.
Your Honor, if I may.
Yes.
The file we actually want to delve into right now is the one which has actually currently been called up, the E769. We can agree with the prosecution that I can see she has been served with the second copy, but the contentious matter is the E769.
Proceed if you are ready.
Yes, Your Honor. We have an application, notice of motion dated the 17th of February this year. We are seeking for orders that the respondent be detained at Muthaiga Police Station for a period of 7 days to allow the investigating officer, Chief Inspector Nixon Kenyan, to complete investigations on a case of publication of false information contrary to Section 23 of the Computer Misuse and Cybercrimes Act, among other offences, Your Honor.
As per section 23 of
Section 23 of the Computer Misuse and Cybercrimes Act, Your Honor. Your Honor, the respondent was arrested on the 15th of February this year at the Lunga Lunga border point and transported to Nairobi, arriving on the 16th via road. And hence the investigating officer has not been able to complete investigations and the investigating officer has sworn a supporting affidavit, which is before this court, noting that the respondent is a flight risk and if it released, it may jeopardize the ongoing investigations. and therefore it is in the best interest of justice for the Honorable Court to grant the orders prayed. One of the investigating officer is before court. That is all.
Your Honor, we are at a crossroads where human rights and liberties guaranteed under the Constitution
Your name again?
and their violation. My name is Maura Kabata. At that crossroad, and I am asking the court to exercise eternal vigilance.
Repeat what you've said.
We are at a crossroads on human rights and liberties being protected and guaranteed, and their continued defilement. I am asking that as officers of the court, we
You're
do the
saying
following.
human rights and liberties being protected.
Protected and guaranteed. The crossroad. One path is on human rights protection and guarantee. The other one is on their violation and defilement. In exactly 2 hours from now, Mr. Mwabili will have been in the hands of the DCI for 48 hours. The only ground they are saying is that he's a flight risk, especially this one. Your Honor, don't get it on record, because I want us to agree on something. There are two applications before the court. One prays for custodial orders, the other one prays for a search upon the premises
We'll
of
deal
Mr.
with one after the other. You cannot deal with both
I am
at the same
saying,
time.
and that's why I had asked Your Honor to allow me to just finish, because I may be of help. Now, on this one of search, as counsel, we are agreeing and saying we can concede on that one.
The one for such.
Yes, you
That
see, Your Honor,
is
I'm
the-
actually helping.
The one of E77.
Yes, we can concede on that one, and they can actually, the prayers there, if read out to counsel, we can concede on that. Then we move to the second application, so that we also give a fair chance to our colleagues from the DPP to concede on it,
So they concede on.
which will then lead us to the inevitable conclusion that, Your Honor, you will be bidding us a good evening so that we leave your premises. To me, it will help us in disposing the two applications. Whether they agree with us or not, we will be conceding on that or not, on the search warrant on his premises. So the court will just read out the prayers so that we record a consent. I am helping the court as an officer of the court.
Wanjiru, are you getting it?
Yes, Your Honor.
Are you getting what he's saying? And are you,
Yes, I understand that they are conceding on the search application.
and that is E770.
Yes.
So
Yes,
are you now also conceding on the
No,
other
Your
one?
Honor. While we welcome the guest, we are not conceding on the. Our instructions are to seek 7 days custody orders.
So let's record this consent and then we go back to the other one.
So, the application is dated the 17th day of February 2026. Under miscellaneous, mine does not have a number, but it is E770 of 2026. It says that the first prayer is that the application be heard inter partes. In the first instance, we can record that that one is spent. Number two, that the Honorable Court be pleased to issue an order authorizing the DCI Digital Forensic Laboratory to analyze, extract, and print out where necessary evidence material from the respondent's smartphone, namely Samsung A26, already in the applicant's possession. That particular gadget is already with the police who arrested him, and contrary to what is being said, he was presented today, not yesterday. And number two is that the Honorable Court be pleased to issue an order compelling the respondent to disclose to Nixon Kenyan, investigating officer, to the applicant, all their
I can
passwords.
just record that that application is allowed.
Yes.
Your Honor, we are at a crossroad because we thought we would be balancing two interests. One is on conceding on this so that the investigating officers can have a smooth ride. But then now, if we concede on it and then we are left juggling on the other question of detention, then it will have beat our purpose. We'll just be straightforward handing ourselves to the guillotine. You can't have your cake and eat it. What I'm saying is, it's a trade-off. For one application we concede, but also they concede on the other application, so that we live here with Mr. Mwabili with one surety, that on the day that the court will give us to come back before it in any mention or further hearing on these applications, Mr. Mwabili will be reporting to the officer commanding station to he's courteous enough. He lives in Muthaiga. He says Kiamburu, but it's Muthaiga. So he will be reporting to the officer commanding station, Muthaiga police station, every day as a condition. He's not a flight risk. His passport can be
I can give my passport.
he can give his passport to me to keep it for him.
Your Honor, actually, we hear the counsels, and our application, Your Honor, is actually merited on the basis that the suspect, Your Honor, has been on a run for the longest time, Your Honor, and therefore, when we say he's a flight risk, we actually mean he's a flight risk. And we can agree, Your Honor, and concede on maybe reducing the number of days, maybe from 7 to 5. But we're saying that we concede on the application of custodial in its entirety, Your Honor, we find that quite risky on our side as the prosecution. And we find, we are praying this court to find our application merited under section 36A 5.
No, you have not even argued the application.
You know,
we were on the one on E770 about searching.
Correct.
And that one is what they were conceding, that
Yes.
the same be allowed. The gadget is already in your custody,
yes, sir.
the phone. So that now, on that one, there is no contest. The court states that it's allowed, you can have the phone analyzed, then we give a date when to come back.
But in that same instance, we are asking, because the ground is on flight risk, it is just one ground. We are asking our colleagues from the DPP to consider on this arrangement.
So that again, you concede on the one of
Yes,
not having
that's
him in
all,
your
so that he
custody.
doesn't have to stay in
He
custody.
doesn't have to stay.
He's a
with you.
law-abiding citizen. He has not been on the run.
You know, the investigating officer is before court, and they indicate clearly that they have been looking for this suspect for the longest time possible.
So
Therefore-
you build.
Pardon, Your Honor?
So from what I'm seeing then, it means let's start with the one for custody. The one they are conceding, we abandon it for now.
Because they had already considered, Your Honor, we can take it at. No.
Your Honor,
You know, it's about balancing the scales.
Yes,
It's not.
yes.
It's give and take. You have to agree. In fact, this is something you would have engaged in before the court came in. Because one, we don't have time. We've registered this application late. We've come before court late. The time is going. It's your case. They are conceding. You also see where you can give it.
And actually, that's why I was indicating, Your Honor, in the good spirit of conceding as my colleagues. We
So
are.
then in that case, now that you are not agreeing, argue your application and take note of time. There is no time.
If they agree, but Your Honor, you can reduce the number of days. instead of 7, we can.
Your Honor, there's a material issue that the person before the court has raised which perplexes me. When our colleagues from the DPP and the investigating officer are saying that he has been on the run,
you are
my device says 4:35. I am.
If you can't use
I
30
am
minutes,
saying
we
again.
have to take it to tomorrow. I'll not go beyond 5.
And I agree with you, Your Honor. I'm raising a very pertinent constitutional issue.
I think the problem we are having now, let them argue the application,
In
we
fact,
respond.
in fact, it will help.
It will help.
It will
Yes.
help.
So that-
Your Honor has been trying to help. I don't know why, Your Honor. In fact, Your Honor, I think I should get a commendation because I've really been on the side of helping. You see, I
You
started
have
with
helped
conceding.
until they are not appreciating the help.
Now I am saying, on the question that the investigating officer says on the record that he has been on the run, the warrants are dated January 2025. Incidences that happened post.
No, they are laughing. They are not even listening to you.
No.
I'm saying that.
The DPP laughs as they communicate. That's their way of communication.
Okay.
On July 24th, 25th, 26th, and 27th, Mr. Mwabili was abducted. And he was not abducted by citizens of Kenya. He was abducted by lawful firearm carrying individuals. Now, why am I saying this, Your Honor? Is because the warrants are dated January 2025. Mr. Mwabili is abducted. He is traveling back to Tanzania to go and get his benefits.
Let's deal with the one that is seeking custody, because I think if I determine that one,
That is the one that we are dealing with. I am saying,
769.
yes, I
Yeah,
am
the issue
saying,
of conceding has been
and that's why I'm saying,
769. Okay, the one for custody.
yes,
Argue your case.
it's not even arguing, Your Honor. I am saying
Yes.
that the lawful authorities, my brother, I did not get your name, Dixon, Kenyan, we are colleagues. You don't have to be my enemy. I will forget about you when I leave the court. He deponds that he's a flight risk. Just one issue, he's a flight risk. We want to mitigate in between. We are saying, because Mr. Mwabili's residence is known as they were kidnapping him and abducting him, could we compromise and say that he will be reporting to the officer commanding the station at Muthaiga police station every day at 9 a.m. without fail? Until that application is heard and determined, or until a charge sheet is formally placed before the court. In the alternative, in the days that they are asking to continue detaining Mr. Mwabili, after those days are done, could they issue a formal apology to Mr. Mwabili? Because we find no reason as to why the physical custody of Mr. Mwabili would necessitate their investigations. We have compromised on the first application. Somehow, the court should be guided that Mr. Mwabili and our team are really eager for a formal charge. Surely, Your Honor, we are not asking for heavens. We are asking for a compromise so that Mr. Mwabili today can enjoy the warmth of his, I wanted to say wife, but let me use family. Please, it is not a hard ask. To ask for 4 days from today, that means that over the weekend, Mr. Mwabili will be in custody. If we can even come back tomorrow with Mr. Mwabili, that's a compromise that we will win. It's a simple ask. I am pleading with my colleagues from the DPP to listen to reason, so that instead of punishing someone who has already been in custody since Sunday, he can be let go home today and come back before this court on Friday for a ruling of that application. Your Honor, again, I do not want to take a lot of time. Allow me to call my colleague, Mr. Mutiso, to say something in 3 seconds, as lawyers who say 3 seconds.
Your Honor, I not only succeed my senior's sentiments and arguments, I wish to just point on 3 issues. The miscellaneous application highlights Section 23 of the Computer Misuse and Cybercrimes Act. Secondly, this is not a charge that requires custodial to be granted for them to investigate, noting the gadgets are already in their possession. The third is on the matter of his right to liberty and the rights of an arrested person. The intended accused person, according to the state, they believe he has been a flight risk or he has been evading the state. I pointed out to the court that there is no summons or warrants on that application. 2, the intended accused person has been residing in Kenya ever since July of 2025, since he was summarily fired under illegal circumstances. His current abode is known. Therefore, as it stands, the state has everything for them to investigate the current alleged charge. And in finality, my lady, the intended accused person, as you know, his rights to liberty have actually already been infringed.
You are repeating yourself.
Most obliged. If that has been captured, I concede my arguments, and I leave 2 minutes to counsel.
There may be a development here. Let's just hear it out from the DPP and then we see whether we will take it. There may be a compromise.
No, you know you're interfering.
I'm a thorough negotiator, moving around, picking emotions.
This you should have done before the court came.
We
For now, let me just record.
No, you're taught not to speak to each other.
I'll give my minutes to him.
So you'll not speak?
Yeah.
All right.
Go ahead.
Your Honor, there may be a slight development which, if we allow parties to interrogate, we may be able to.
So we break?
No. We may have had a conversation.
I'm also going to make a decision anyway. So you have a consent?
I am informed that
Maura Kabata, I think now, I'm sorry to say your conduct. You are simply interrupting the court. We had proceeded very well, and I'm recording what you are saying,
what we
and
had
I'm ready to
agreed,
make
what we had
a
agreed was also to compromise that application so that he is detained for 1 day. It's a prayer that is in the application, but now the development seem to have hit a snag for the court is to allow parties, the DPP and the defense team.
The court will make a decision. Why are you worried? You've made your submissions, your colleagues are making, and then we get a decision.
Your Honor, if the court has already predetermined the matter, then I am of
The
no
court
service.
is not predetermined.
I
but
will not
we-
be of service
we
if the court
cannot-
has already made up its mind.
There is no
I will
mind
be
made.
asking that I leave the court.
The point is, we cannot go back and forth. The prosecution have made their case, you have made their case, they will do another reply, then we move. But now as it is, we are not moving. We are not moving.
Your Honor, I would refer the court to the case of Oscar Sudi. It's 2020 EKR, where Justice
Your name again?
John Minor, where the Honorable Ngugi formulated
The case of?
Sudi Oscar Kipchumba versus Republic. Is 2020 EKR, where Justice
2020?
EKR, yeah, Justice Ngugi affirmed in paragraph 24 of the judgment, where he formulated what is known as the double test in cases of miscellaneous detention. Your Honor, the first limb of the double test is that where a person is to be detained, it must be in exceptional circumstances. Your Honor, what you have seen from the prosecution, there is nothing urgent or exceptional in nature. Your Honor, we are being told that the respondent was arrested somewhere in Lunga Lunga, 2 days brought to Nairobi. Your Honor, we wonder whether in Lunga Lunga we don't have courts where he could have been taken 2 days ago. Your Honor, further, the second limb that Justice Ngugi formulated is that the state must demonstrate that the continual detention of an individual without charges is the most restrictive action that can be taken. Your Honor, in the context we are, the state has not presented any compelling reason before the courts. The state is only giving us a tirade that the respondent is a frightful risk. Your Honor, in the case of Jackton Maende, the courts affirmed that where there are allegations that the respondent is a flight risk, tangible evidence must be placed before the court. Your Honor, what we are hearing are just stories that he is a flight risk, but there is nothing tangible that has been laid before this court to affirm the position. Your Honor, as I wind up, the essence or the import of Articles 21 and also 259 are there, not so that the prosecution negate that, but to aggrandize and put import in them. So, Your Honor, what we are hearing here is neither here nor there, and we pray that the court affirm what we have been saying, that there is nothing before the court that affirms the position that it should be continually be detained. Now what I'm getting is also what we had consented to the court insofar as such is concerned is withdrawn. The instructions we are getting from clients. If you cannot batter it around, then that consent is no longer tenable.
It had not even been recorded.
Yeah.
I already saw that there was no agreement. Prosecution? Any reply?
Good afternoon, Your Honor. Apologies, I came in a bit late. But, Your Honor, very briefly in response, we very humbly submit that the prosecution has indeed availed compelling reasons why the respondent should be remanded for the days out, Your Honor. And mainly, the main reason, Your Honor, being that is a flight risk. Your Honor, as per application, the respondent was arrested at a border crossing point. And Your Honor, that can only be construed in one way. That was trying to, it was an attempt to flee the jurisdiction. And for that reason, Your Honor, we very humbly wish to submit that if released, Your Honor, the investigations, ongoing investigations, Your Honor, will be prejudiced. And Your Honor, we also wish to inform the court that since 14th of January 2025, the accused person, having been notified and to attend to the investigators here in Your Honor, did not comply.
Your Honor, there is a point of objection, mainly because I don't know what prosecution is referring to, and it wasn't part of the application, and that is not a document which was actually in our possession.
Talk to your client that he has representation, he should be quiet.
Okay. But Your Honor, we shall withdraw that line of submission, and now I will cede the ground to my colleague, Mr. Nyaga.
Let's just to finalize and say that the application that you're making, Your Honor, is squarely within Section 36A. And we pray that this court to find the requirements of Section 36A5 having been met. And just to outline to this court that it has discretion to issue a custodial order of up to 30 days, and we are only seeking for 7 days, Your Honor. So our prayer is that the court finds in our favor because of the reasons and grounds that have been submitted, and to allow the investigating officer the 7 days as applied for in order to finalize and complete on the investigations.
Just a point of concern. I know, just a point.
You know the law. Your right of reply is as what is the time?
That is 4:55 p.m. 5 minutes.
So that is one application, it's for my ruling. And the other one, where the LSK had conceded.
It's since withdrawn. The
So you
concession.
want to argue, you can argue the same.
Your Honor, if I may,
It's the prosecution to to argue, then you.
Yes,
reply.
I was about just to suggest that, and then I think my rebuttal is going to just be 1 minute on it.
Okay.
Yes.
E70, E770. The LSK had considered that you can have the gadgets. They will not oppose, but you allow the accused to be free.
Free.
I don't know whether you have a problem with that. Brother, now that you,
Yes, Your Honor.
it was being looked as a balancing the.
Indeed.
You will surrender the gadgets you need,
Yes.
some which are in your custody, as they say,
Yes.
and then you allow him to be reporting to the police every day.
Your Honor, I think that is what the conversation that was going on, but they were asking for 1 day, and we are conceding 2 days. Taking giving them
days,
2
okay.
days until Thursday.
If I may address the court, Your Honor.
No.
No. If in what we had actually placed before you for consideration before the prosecution, it was
No, if it's not okay, you just say it's not okay.
it's not okay. We're not
Then what you
conceding
do,
for.
let the one for the warrant, you can argue there. E770.
Yes, Your Honor. Yes, Your Honor. Sorry. We're on number 7, E770. Miscellaneous application before you. Carrying on the prosecution. The eye of the prosecution is seeking for orders that a mobile phone, Samsung A26, that was recovered from the respondent. Your Honor,
I'm told the phone is already in your custody.
yes. The same may not be subjected to forensic examination. The reason being that the respondent was arrested on suspicion of publishing of offences under the Computer Misuse and Cybercrimes Act. And having been arrested only yesterday, Your Honor, we shall be praying that the court grants the orders as sought.
Your Honor, in reference to application 770 of 2026, we do acknowledge that the device is actually in the possession of the investigating officer who is before the court. My only concern is to highlight on the limits of what is supposed to be searched on that mobile phone. I reiterate Article 31. And I also make reference to miscellaneous application 1640 of 2025.
You said the exception you have is?
The limitation as to what is to be searched on that mobile phone.
So you are limiting to what?
What they have highlighted in the miscellaneous application as to far as paragraph number 5, that is into searching the X account of the intended accused person, more so any
So it should be limited to the X account.
to the X account and not to any other content, data pertaining to the intended accused device. And I qualify that particular argument on a miscellaneous application number 1640 of 2025 which is publicly known as blood parliament. The nature as to the broad prospect of what DCI searches is copy the whole mobile phone. And we have tabled documentary evidence, and there is recordings as to the matter before this honorable court. Therefore, we just want that to be limited to that particular scope.
So it's be limited to the X account.
To the X account. There's nothing else which has been referred there.
Prosecution, any reply?
Your Honor, our miscellaneous application is very clear that we are only pursuing what was contained in the X account in issue. And also...
So you are conceding?
Yes, Your Honor, we are conceding, but we also, beyond that, we want to establish the ownership of the device, linking the same to establish whether there is any linkage with the respondent with the device. So, Your Honor, we are not asking for anything more, even in our application.
I just want it to be on the record. Should we get the forensic report on the device and it goes out the scope, we can come here for perjury and also for contempt on that.
Your Honor, I do not understand why counsel is preempting things that have not been raised. I think, Your Honor, our application is clear and we should limit ourselves to the matters before court.
I think the point has been made.
Can I say something with
You know the law. I've had both applications, and due to lack of time, I'll make the ruling tomorrow morning in both applications.